So let's talk about that. Let's start with terms and conditions, which unbeknownst to most people who are in direct response in e-commerce, this is a contract, a binding contract between you and the person who's paying you. So talk to me about that, the do's and don'ts and must-haves.
In terms of the substance of terms and conditions, class action waiver language, mandatory arbitration. Class action waiver is exactly what it sounds like. Mm-hmm. Anybody who's buying a product from you waives the right to be able to participate in class. Mandatory arbitration, same thing. You don't get to go to court and litigate anymore. You have to go to arbitration, which is confidential, typically less expensive, although recently it's been a little bit less so. Those are the two big ones. And then how do you actually get consumer acceptance to that? I mean, think about it. It is actually a contract, despite what everybody thinks. It is actually a contract. And so when you get to that checkout page, you need to be ensuring that whoever is buying that product is actually taking some kind of affirmative action to, essentially sign their name to this agreement. And I think that happens in several ways. It's usually a checkbox by saying, by checking this box, I agree to terms and conditions or terms of sale and privacy policy. That affirmative checkbox, is incredibly important. It needs to be linking. You actually need to hyperlink those terms of sale in the privacy policy. It needs to be in blue. It needs to be underlined. And the reason that is so important is that you need to be putting the consumer on notice, being like, hey, you see those big terms of sale language? Right. That's actually a document that you need to look at. And by checking that box, you're agreeing to waive some rights. And you don't really care if they read it or not, but you have to give them the opportunity. You hope that they would read it, but nobody ever does. But you just need to give them the ability to read it.
I just want to throw one thing in there that you didn't say that I would like to make sure people know. Have your refund policy well spelled out on those terms and conditions, well spelled out, particularly for purposes of chargebacks.
Processing.
Right. When it comes to payment processing, even though your chargebacks are chargebacks, but you want to be able to win those chargebacks if something were to happen.
Yeah, because a lot of times there will be a refund page on the website, which changes all the time. It really needs.
It needs to be in your terms and conditions.
True.
So let's move on to privacy policy.
Yeah, big thing. It is say what you do and do what you say. Mm-hmm. Tell
with the data.
Tell people what data you're collecting, how you're using it, and actually follow it. If you are telling them that we are collecting this data and we're using it this way, you actually need to be doing that.
And let's talk about those ways, because I think that there's a big disconnect in the industry of what you actually have to disclose. So if I'm using their email address to create a lookalike on Facebook, I have to disclose it.
Yes.
If I'm creating a duplicate list and I'm setting CPA offers to the duplicate list, do I have to disclose it?
Yes. Well, it doesn't need to be like I'm doing.
We're gonna get to that. We're gonna get to that. If I'm setting affiliate offers to them, do I need to disclose it?
Yes.
If I'm renting the list to other people, do I have to disclose it?
Yes. I
think I already said the Facebook lookalikes. Mm-hmm. There's a bazillion different ways that we use data. If I'm analyzing the data for purposes of marketing, like I'm going through and I'm analyzing their data, where they live, what their demographic is, do I have to disclose that?
Yes.
Okay. Now let's talk about what you're itching to talk about.
No, but you don't have
to spell that out.
You don't have to spell it out, but you can use how are you actually? We're using your email address for XYZ purpose.
Let's kind of, because you keep saying XYZ. Let's quantify it for people though.
So we're gonna.
So I'm using your data. I'm going to take your email list and I'm going to create a list of buyers and I'm going to create a lookalike audience on Facebook. How would I word that?
You're gonna loosely. You're going to say that I use your email address for probably cross-contextual advertising, as well as I don't think you actually would need to spell out lookalike audiences, but advertising and marketing purposes.
Right.
So
it doesn't. You have to spell out what you're doing, but you don't have to use the words that we would use. Mm-hmm. You have to use the words that legal jargon would use, right? So important to have a lawyer look at it.
Well, and where it gets more complicated is one-to-one consent. It's, you may be giving your data to me. If you are giving it to somebody else, do they actually have the authority to use it? And that's when it gets into contracts between, you as a business and them, and then whether or not the consumer has the right to control that data. Telehealth companies get into this all the time because they're coming into contact with, personal, very sensitive information. Even dietary supplement companies that are running surveys, they're like, take my survey. Do you suffer from X, Y, and Z? All of a sudden they have a massive amount of data, which is great for audience building. But, is that going to start triggering like my health, my data in Washington? It gets complicated.